Welcome to the Wiley Rein Federal Gift Rules App podcast. I'm Rob Walker, and I am of counsel in Wiley Rein's Election Law and Government Ethics Practice Group. Just for a little background on me, I'm a former federal prosecutor, former federal public corruption prosecutor, and I'm the former chief counsel of the House Ethics Committee and subsequent to that of the Senate Ethics Committee, and I was a bipartisan hire in both of those positions. What I would like to do in this podcast is to kind of elaborate on some of the important process points and general rules of application covered in the gift rule app itself, and provide some ideas or some basic pointers, at least, with respect to compliance programs and what some of the elements there ought to be, and then talk just a little bit about some of what you might call between the lines points of some of the specific gift rule exceptions and exclusions covered in the app. So let's start with why you need to get the gift rules right. And here, as really throughout this podcast, the you I am primarily talking about are businesses and other organizations registered or required to be registered under the Federal Lobbying Disclosure Act. I'll be calling it mostly the LDA as we go along. And so organizations and businesses registered or required to be registered under the LDA, as well as employees of such organizations. That's the you I'm talking about here. Of course, the requirements also apply to lobbying firms, their individual federal lobbyists, and to their other employees as well. So let's start with the congressional gift rules, that is, the gift rules of the U.S. House and the U.S. Senate, and why you need to get those gift rules right. And maybe the first point to talk about, or the first factor to point out, is that under Section 25 of the LDA, organizations registered and any individuals disclosed as lobbyists under the LDA by those organizations may not make a gift or provide travel to a covered legislative branch official, which is essentially any member or staffer of Congress, if the person has knowledge that the gift or travel may not be accepted by that covered official under the rules of the House of Representatives or the standing rules of the U.S. Senate. So there is essentially that provision of the LDA that makes compliance with the rules a requirement for registered organizations and their employees. And a second point is that also under the LDA, through the semi-annual Form LD-203, every organization registered to lobby and each of that organization's federal lobbyists must also certify twice a year that they essentially know the House and Senate gift rules and that gift and travel rules, and that they have not knowingly provided a gift or travel in violation of those rules. So there's a very specific why you need to get the gift rules right with the congressional gift rules. Violations of those provisions I just talked about are potentially subject to civil penalties, including potential fines of up to $200,000 per violation if they are knowing violations. And if a violation is knowing and corrupt, and that's the language of the LDA itself, that violation is potentially subject to criminal penalties. Now, no such criminal penalties have yet been brought under the LDA, but in this day and age, there is always a first time. And I don't think anyone listening to this podcast wants to be in the position of being the first. So, under the LDA, to drive the point home, organizations may be liable for violations of the congressional gift rules. Individual lobbyists could be liable for violations of the congressional gift rules. And for an organization, that would include violations by any of the organization's employees, whether or not the employee is a federal lobbyist or works in the GR department. So we have been talking so far about why your organization and its employees need to get the congressional gift rules right. But what about the federal executive branch gift rules and regulations? Unlike what we have seen and what I've talked about, I should say, with regard to congressional members and staff and gifts to them, the Lobbying Disclosure Act does not contain any compliance certification or disclosure requirements relating to gifts to officials and employees of the executive branch. But notwithstanding that, of course, knowledge and compliance with executive branch gift restrictions remains essential. First of all, and this is certainly true in the congressional context as well, it basically, I'm sure, goes without saying that compliance with applicable rules, regulations, and statutes is an important organizational policy and goal in and of itself. And second, your organization and your employees need to know what constitutes a gift to avoid, for example, concerns about so-called improper linkage that may arise if the circumstances surrounding a gift suggest some causal tie to any official action being sought, or suggest that a gift may have been given as a thank you for an official action already taken. And even if the circumstances of such improper linkage fall short of an illegal bribe or gratuity, the cost to address such concerns, to investigate, to respond to any agency investigation, to address any appearance or PR concerns, those costs can be quite high. So that's kind of the why you need to know. And so with the House and Senate gift rule related provisions of the LDA through the LD 203 form primarily in mind, let's talk about some steps to take in your organization's efforts to make sure you are being duly diligent on gift rule compliance. And my emphasis here is on some steps, since we're not going to go over here of kind of full treatment of possible compliance programs. So a key point to be emphasized here is that due diligence throughout the semi-annual reporting period is needed so that you are not, for example, after the first 6-month period is over in July, trying to scramble to collect, organize, and analyze information as the reporting date approaches at the end of July. And so that as much as possible, you can avoid them, rather than dealing with them after the fact. So as an additional spur to appropriate compliance procedures, remember that the Lobbying Disclosure Act requires the Comptroller General, the head of the Government Accountability Office, to undertake random audits of lobbyists and registrants under the LDA to determine the general extent of compliance or noncompliance with the LDA's requirements. So the Comptroller General may request from individuals or organizations such information as the GAO deems necessary. So here's another reason to make sure that you have some specific and articulated compliance procedures and record-keeping procedures in effect. Also, remember that the LDA not only requires certification as to familiarity and compliance with the congressional gift and travel rules, but that a separate provision, as we've already talked about, imposes increased civil and criminal penalties for providing gifts in violations of these rules. So let's talk about some steps, as I said, that might be taken to assure or work towards compliance with the gift rules. First of all, make sure that your organization's employee policies, handbooks, and manuals adequately address the gift rules, address and explain them. Make sure that these materials are made available to all employees, particularly to those who have or are likely to have contact with federal government officials, and make sure that the materials stay up to date. While changes to the gift rules don't happen every day or even every year or every Congress, they do happen from time to time. And so it's important to make sure that you keep your policy, handbooks, and manuals up to date. Another step that you might take in your organization is to provide periodic email reminders to folks about the gift rules, maybe covering some particular issues that may come up or situations that may come up with specific frequency in your organization. Email reminders of this kind that come along periodically, they keep the relevant rules and requirements continually current in the mind of employees. And those kinds of updates also serve to demonstrate continuing commitment by the organization to complying with the gift rules and with the reporting system and certification requirements of the LDA. Another area in which you might and should probably impose some compliance steps is in connection with disbursements and reimbursements to your employees for expenses. The best approach would be to have a system of pre-approval before any funds may be dispersed in connection with any proposed interaction with a federal government official. And of course, we're just talking about the federal gift rules here. You might have a similar system with respect to state gift and ethics requirements, depending on the states in which your organization operates. But a system of pre-approval really would be good. But also, it's important to make sure that the reimbursement process captures and allows appropriate scrutiny of any expense related to interactions with federal government officials. So the disbursement and reimbursement point is a very good point at which to make sure that there is gift rule compliance and to get hopefully an early warning as to whether a gift rule issue might come up if a particular disbursement were allowed. So that's really a kind of a crucial point in the compliance process right there. You also in your organization might want to make sure that, and this depends on the size of your organization, obviously, and how it's structured, you might want to get certification from managers of various units that neither they nor the employees who work for and with them have given any gifts or travel in violation of the gift rules, and that they're familiar with the gift and travel rule requirements. This would help assure and demonstrate that the overall LD-203 certification for the organization submitted to the House and Senate reflects organization-wide compliance. And then, of course, always an important element of any kind of compliance program is training and education. Many of the potential issues and pitfalls that might arise under the congressional gift and travel rules are simply not apparent to people, kind of novices in the field, until those rules and requirements are specifically talked about and talked through. And this is an area in which there definitely is no such thing as a stupid question. And there should be regular organizational opportunities for questions in this area to be asked and to be answered and addressed by people familiar with the ins and outs of the gift rules. So again, there are some steps to keep in mind in connection with your compliance programs in this area. Let's now talk about what I referred to at the start here as some between-the-lines points about the gift rules. These are points where maybe there might be a subtle difference between the congressional gift rules on the one hand and the executive branch gift regulations on the other, or even between the House and Senate gift rules. And although the House and Senate gift rules are largely the same, there are a few areas in which the House and Senate apply the gift rules or interpret the gift rules somewhat differently. So we'll hit on maybe just a couple of those here. So let's talk first about one of the so-called exclusions from the executive branch definition of what constitutes a gift. And so let me differentiate exclusion from exceptions. In the executive branch, as you see from the app, there is a very specific and detailed set of exceptions to the basic gift rules, but there are also a number of exclusions. That is, items that are excluded from the definition of gift that do not even constitute gifts. The items that fall within exceptions, on the other hand, may be gifts, but they are generally allowable gifts. Here, I'm going to talk about an exclusion, and that is the exclusion for modest items of food and non-alcoholic refreshment offered other than as part of a meal. Now, that exclusion sounds a little bit like, and maybe a lot like, the similarly worded congressional gift rule exception for food and refreshment of nominal value offered other than as part of a meal. But in fact, the executive branch exclusion is much narrower in scope and allows executive branch officials and employees to accept much less in the way of food and beverage than the similarly worded congressional exception allows. The congressional exception for food and refreshment of nominal values offered other than as part of a meal is typically known, and it's referred to also on the app as the reception exception. And if the terms of this exception are met, that would be, for example, for an evening reception, hors d'oeuvres or appetizers of so-called modest or moderate value. That simply means non-luxury items. And then drinks, even an open bar, that would be okay generally under the House and Senate reception exception. However, under the exclusion in the executive branch, that is very limited to items like soft drinks, coffee, tea, donuts, very, very limited items. So you can't really get into a reception, so to speak, under that executive branch gift rule exclusion. To accept comparable items in the executive branch as an individual under the congressional reception exception, as someone coming from the House or Senate could accept, in the executive branch, the event would likely have to qualify as what is called a widely attended gathering. And widely attended gatherings sponsored, so that is one thing to keep in mind. To get into a reception where there are past drinks and hors d'oeuvres, an executive branch person would have to get written approval ahead of time in almost all circumstances that that event qualifies as a widely attended gathering. But even there's a glitch, because suppose your organization is putting on a reception, there will be a sufficient officially related component such that individuals from the executive branch and the legislative branch may attend, and individuals from the executive branch may get approval that it qualifies, written approval that it qualifies as a widely attended gathering. Suppose that is all the case. Here, however, we have to turn now to the special set of restrictions that are imposed in the executive branch on political appointees. Political appointees in the executive branch under the Trump Ethics Pledge, Executive Order 13770, are not allowed to accept gifts from lobbyists or organizations that employ or retain lobbyists. And that lobbyist gift ban is carried over from the Obama Ethics Pledge, but the exceptions that are permitted to that lobbyist gift ban for political appointees are very, very, very limited. And the widely attended gathering exception, I won't go into the details of what the provisions are there, but the widely attended gathering exception is not available to political appointees. So to get into your event, if you put on an event, as I described, where there are hors d'oeuvres and let's say there's an open bar, and let's assume that it relates to the official duties of an agency official and it would be officially related attendance. To get into that event, a political appointee from the administration would have to either pay fair market value, fair market retail value, or with agency pre-approval, that official appointee, that political appointee from the executive branch might be able to attend and should be able to attend if they are going to have a speaking role at the event or they're otherwise going to present information at the event on behalf of their agency. So really, you have to keep in mind that there are really two sets of restrictions in the executive branch gift rules. One is a broader set of restrictions for career employees and officials, and then a much, much narrower set of gift rule exceptions, let's say, that are available to political appointees. As you can see, even attendance at a simple event is going to raise different gift rule issues depending on who you're inviting, whether they're from the House or the Senate, or whether they're from the executive branch. Are they career officials? Or are they appointees? This all points to the fact that you're going to want to make sure that you work out issues, gift rule issues, well in advance of any event that you plan and to which you plan to invite federal government officials. You don't want to leave these kind of questions and addressing these questions to the last minute in planning, because you don't want to come up in a situation, let's say, where you might have to withdraw an invitation that you've already extended. So working these issues out in advance is important, and that's another reason, frankly, why you need to know what the gift rules allow and what they don't allow. So we talked about the reception exception under the House and Senate gift rules, the exception for food and refreshment of nominal value served other than as a meal. And there is also a House exception for items of little intrinsic value. And that would include, under that exception, baseball caps, greeting cards, and T-shirts of reasonable value, and those items are all enumerated in the gift rule exception itself, but also included would be any other non-food item under $10 in value. So if you take the reception exception together with the item of nominal value exception, a question might arise, well, can you provide kind of under $10 value food items to members or staff of the House or Senate? And the answer is essentially no. An important takeaway here is that no one-on-one food or beverage really may be provided by representatives of or employees of entities registered under the LDA. No one-on-one food or beverage may be provided by such persons to members or staff of the House or Senate. That is a very important point to keep in mind. So you can't really just buy someone a cup of coffee. You can't buy them a hot dog, even if the cup of coffee in this day and age, maybe it wouldn't be, but usually they're still under $10 in value. It doesn't matter. One-on-one food and beverage or a meal or a cup of coffee, not permitted by representatives of and employees of any organization registered under the LDA, not permitted to be provided to members and staff of the House and Senate. So, of course, I say that, and there is kind of an exception to that, very minor, and it really doesn't change the basic guidance there. In the Senate Ethics Committee has essentially determined these provisions to permit a Senate office to accept perishable items, including, let's say, flowers, valued at under $10 in the aggregate, and the exception allows those items to be delivered to the Senate office and accepted in the Senate office. But the intent behind this approach is to allow an office to accept such items from constituents, not to have to face the kind of embarrassing situation of sending some nominal value flowers, let's say, back to a well-meaning constituent. This provision or this mode of interpretation by the Senate Ethics Committee was not intended and does not allow staff in a Senate office to accept certainly meals or coffee. So let's talk about another difference, and that is a Senate kind of approach to interpretation of that exception only. That's not available on the House side. So let's talk about another difference between the House and the Senate in terms of either applying or interpreting similar gift rule provisions. The House has taken the gift rules and they have created kind of an additional blanket exception that allows House members and staff to accept site visits at a plant, a factory, or some other manufacturing or business site for obviously purposes of touring and fact-finding at the facility. And this exception on the House side may include local transportation to the site being visited. It may not include long-distance transportation. And the site visit can be in the member's home state, or it really can be anywhere. Now, in D.C., if there's a site visit at a site in D.C., local transportation is not going to be available. So that is a very useful exception and a very important exception on the House side. However, no similar provision or approach to application exists on the Senate side. So there is no Senate equivalent of this House site visit exception. The closest thing to it on the Senate side is the provision in the gift rules, and this is only in the Senate gift rule, for events that take place in the member's home state, in the senator's home state, at which 5 or more constituents will be present. There has to be some connection with official duties of the member or staffer there. But no registered lobbyist may be present at this event. But if otherwise these criteria are met, a meal of up to $50 in value may be provided to the attending members or staffers. And local transportation would be permitted as well. But again, not long-distance transportation. And so then let's talk about one final kind of difference in application between the House and the Senate on a similar, in fact, identical gift rule provision. At least the language of the provision itself is in the House and the Senate is identical. And this is the informational materials exception, which might cover, let's say, books, briefing papers, white papers, periodicals sent to the House or Senate office. In the Senate, those materials may only be accepted in the Senate office if they come from the author, publisher, or producer of the materials. On the House side, although periodical subscriptions may only come from the publisher, other items, for example, books and briefing papers, white papers, may come from any source. So that is an important distinction as well, and something to keep in mind. And another reason why you want to know the ins and outs of all of the congressional gift rules, because if you have a book that you think is important for members to read so that it can inform their thinking about the issues before them, you may have difficulty providing that book to all members of the Senate, whereas you might be able to do it on the House side. So if you want a kind of unified campaign in providing the same information to all members of the House and Senate, you're going to have to account for the differences in the gift rules. So yet another reason why you need to know what the gift rules on the legislative side and the gift regulations on the executive branch side allow and what they don't allow. Well, that's it for this podcast, just providing some general pointers and some general points of interpretation. Please enjoy using this gift app. Make sure that you contact us at Wiley Rein if you have any questions about specific points that I may have talked about today or that are covered in the app, or if you have questions about gift and ethics compliance program for your organization. Thanks again. Thanks for listening, and talk to you again soon. Bye.